Hi, everyone. Good afternoon, and welcome to Brown and Fortunato's webinar series for hospitals and health systems. My name is Elizabeth Jepson, and I will be presenting today with Beth Jackson. We are both attorneys in the Brown and Fortunato Healthcare Group, and we look forward to talking with you today about the National Practitioner Data Bank. During this presentation, we're going to provide an overview of the National Practitioner Data Bank, or NPDB. Then we want to provide a summary of the types of entities that are required to file reports with the NPDB. And we also want to discuss what needs to be included in those reports. There are a number of gray areas when trying to determine if a report necessarily needs to be filed. So we want to talk through some examples of these gray areas and talk through also some of the new question and answers that were provided in the 2018 update to the NPDB guidebook. Finally, we want to talk about the ramifications of failing to file an NPDB report if one is necessary to be filed. So the NPDB is a confidential clearinghouse that was established under the Healthcare Quality Improvement Act, or HCQIA. And as you may know, HCQIA provides immunity from monetary damages to healthcare entities and participants in peer review actions. However, in order to gain the benefits of this immunity, the professional review body must comply with HCQIA's due process rights for the affected practitioner when taking actions that adversely affect medical staff membership and/or clinical privileges. The U.S. Department of Health and Human Services Health Resources and Services Administration maintains and administers NPDB. And kind of overall, the NPDB is just basically a national database that maintains information regarding professional competence and conduct of practitioners, and NPDB is also responsible for releasing this information to eligibles that are able to query the database. So the NPDB guidebook is guidance published by HRSA regarding the NPDB and reporting requirements. It provides HRSA's guidance on everything related to NPDB, from how to determine if an entity is eligible to report or query the data bank, also what and how to file reports, and also how to query the data bank. The guidebook's available online and includes question and answer sections that provide detailed examples and HRSA's thoughts and opinions on how specific situations should be handled. Some examples of the types of entities with reporting obligations include hospitals, physician practices that conduct peer review, rural health clinics, nonprofit healthcare organizations, ASCs, health plans, medical malpractice payers, professional societies, state Medicaid fraud control units, state boards of medical examiners, other state licensing agencies, as well as the DEA and other federal agencies.
So then the question moves to what things must be reported. And there are several things that must be reported to the National Practitioner Data Bank. Reportable items include medical malpractice payments, healthcare-related judgments or convictions in court. They also include actions against a licensee taken by a state licensing board. But we're going to focus today on the adverse action reporting for healthcare providers and the gray areas that are inherent in the process, especially given the new revisions to the guidebook in 2018. We note that hospitals and healthcare entities must report adverse actions against physicians and dentists. They may report adverse actions taken against other providers, such as nurse practitioners. And I think it may start to trend that nurse practitioners are reported and included in reports and are queried about, given the increasing scope of practice and their importance in the healthcare system. So, for our hospital and health system clients, adverse actions that must be reported include professional review actions that adversely affect a physician's or dentist's privileges for more than 30 days. Chapter E of the guidebook provides additional guidance from HRSA and some Q&As that should be reviewed. We're going to review some of the new questions, but there are other questions that have been in there for a couple years that if you haven't reviewed them in a while, you might want to go ahead and take a look. The key on the timeline for reporting obligations is that it lasts for more than 30 days. This is something that was clarified in the 2018 revisions to the guidebook, and we will talk more about that later. So what is a professional review action? A professional review action is an action or recommendation of a professional review body, such as a peer review committee, based on a practitioner's professional competence or conduct that adversely affects the practitioner's clinical privileges or membership on the medical staff. So this includes restrictions on clinical privileges, proctoring, summary suspensions, and revocations, denials, or failure to renew medical staff membership. But remember, the restriction imposed by the hospital or healthcare entity has to last more than 30 days to be reportable, even if it meets the definition of professional review action. Professional review actions do not include administrative actions or the withdrawal of an initial application for clinical privileges or medical staff membership. The initial application is important because the withdrawal of a renewal application for privileges or medical staff membership may be reportable, and we'll discuss when that is reportable. Purely administrative actions, even if they result in the loss of clinical privileges or medical staff membership, are not considered professional review actions. For example, if medical staff bylaws require board certification for membership and a physician fails to maintain board certification and loses certain privileges as a result, that is not a professional review action. It is not related to the physician's professional competence or conduct, and it's just part of an administrative process. Note, however, that Texas has specific regulations that require physicians a requirement that maintaining board certification is a condition of medical staff membership must be approved by the medical staff and not just the board. So if the medical staff votes to okay it, then a hospital can require physicians to maintain board certification as a condition of maintaining clinical privileges. There has recently been lots of discussions regarding the burdens of maintenance of board certification and some reflection that it may not be reflective of quality, and so that's being reviewed given the costs, time-wise and monetarily, to physicians to maintain board certification. Another important concept is that of investigations. The guidebook takes a pretty broad view of what an investigation is. Investigations are focused on a specific practitioner and are related to his or her professional competence or conduct. They typically precede or result in a professional review action, but they do not include routine processes or reviews like FPPE, like you do for new medical staff members, and a practitioner's knowledge or lack thereof of an ongoing investigation is not relevant to whether something is an investigation or should be reported. So once they're opened, investigations must be closed, regardless of what they're called, or before a final act, and a final action must be taken. An entity's bylaws are instructive and should be considered in deciding when something is an investigation, but they're not necessarily determinative. Just because the entity calls a process something other than an investigation, it may still be considered an investigation for NPDB purposes. Elizabeth is going to discuss the 2018 guidebook provisions regarding investigations and some other gray areas.
All right, so many of the updates to the guidebook that were made in 2018 relate to the timelines and what must be reported. NPDB has consistently interpreted the term adversely affects to look at the duration of the restriction and how it actually plays out, not necessarily how the hospital or health system has written the restriction when it is initially imposed. An important case to review is Walker versus Memorial Health System of East Texas. In 2017, the Fifth Circuit, which is the federal circuit court governing Texas, dismissed an appeal related to an allegedly improper filing of an NPDB report by a hospital about one of its medical staff member physicians. Earlier in the case, the U.S. District Court for the Eastern District of Texas had ordered the hospital, Memorial Health System, to void a report it had previously submitted to NPDB. The hospital had submitted this report to NPDB regarding Dr. Walker because the MEC had put in a proctoring requirement for the next 5 bowel cases that Dr. Walker performed. When the restriction was put in place, it did not specify a timeline, which meant it may or may not have exceeded a 30-day period, just depending on when cases presented. So, but before the Fifth Circuit could review the case and make a decision, Dr. Walker withdrew his appeal, and therefore the Fifth Circuit dismissed the case. So we never got a final decision, but we've learned a lot about what NPDB thinks based on some filings in that case. Much as NPDB had argued in the Walker case in its briefs, NPDB addresses practical effects of proctoring restrictions in the 2018 updates to the guidebook. Per the updated guidebook, if the assignment of a proctor restricts the ability of a physician or dentist to practice, and regardless of how that restriction is written, if it is in effect for more than 30 days, it must be reported. And the clock on this starts as soon as the practitioner is unable to practice his or her full scope of privileges. On the flip side, a proctorship that does not impede or restrict a practitioner's ability to practice, such as post-procedure review of records or receiving approval from a department head, would not have to be reported, even if that review lasted more than 30 days. So, for example, if bylaws require that all new members of the medical staff be assigned a proctor, that would be considered an administrative action and is not a reportable event. Another gray area relates to summary suspensions. Summary suspensions are temporary restrictions of privileges that allow for an entity to conduct an investigation when there is a risk of imminent harm if the practitioner continued to exercise his or her privileges. So when are summary suspensions reportable? Summary suspensions are reportable if they extend more than 30 days, even if there's no final action taken by the healthcare entity within those 30 days. In the commentary to the guidebook, NPDB appears to take the position that if the healthcare entity believes the summary suspension is going to last more than 30 days when it's initially imposed, it would be appropriate for the entity to file a report with NPDB prior to the expiration of the 30-day period. And if for some reason the restriction is lifted prior to that 31st day, then the entity should file a void report with NPDB. This is a little interesting, especially given NPDB's guidance that the key thing is whether or not the restriction lasts more than 30 days. And at least my opinion is that jumps the gun a little bit. So, because if there's final action within that 30-day period, whether or not the summary suspension is reportable is going to depend on what that final action is and if that results in a restriction of privileges. So, for example, if the summary suspension is imposed and within 20 days an investigation concludes without finding any competency or conduct concerns, and then the summary suspension is lifted, that would not be reportable. But NPDB would suggest that that the entity should have filed a summary suspension or a report with NPDB when that summary suspension was initially imposed if it was expected to last more than 30 days. And if for some reason it was then lifted, then the entity would just file a void report. With respect to temporary privileges, NPDB doesn't really make a distinction between temporary and permanent privileges if adverse actions are taken against those privileges. But if a practitioner's temporary clinical privileges expire as a result of time limitations imposed by medical staff bylaws, NPDB would view that as an administrative action that's not reportable. But if a practitioner with temporary privileges resigned privileges in return for the hospital not conducting an investigation or while an investigation was ongoing, whether or not the practitioner knew the investigation was ongoing, NPDB would consider that reportable. One interesting thing to note is that if temporary privileges are time limited and not renewable under the entity's bylaws, and privileges expire while an investigation is ongoing, NPDB has said that this is not reportable because the physician could not renew the privileges, the temporary privileges that are time restricted under the bylaws, and that this is different from typical situations where permanent or renewable privileges expire and are not renewed while an investigation is ongoing. Yet another issue that often comes up is impaired physicians, and many times investigations that are started will reveal problems with drugs or alcohol in certain practitioners. If a hospital takes an adverse action as a result of an investigation related to a practitioner's competence or conduct, and part of that action requires the practitioner to enter a rehabilitation program, what should the entity report to NPDB? Well, there are two different issues. So first, if the adverse action is a restriction on privileges, then the practitioner must have privileges restricted more than 30 days to be reportable. And if that's the case and the restriction lasts more than 30 days, then the restriction should be reported. But the fact that drug or alcohol treatment is part of the restriction or is required by the hospital should not be reported. Another situation that may come up is a situation where there's no adverse action taken against a practitioner, but the practitioner voluntarily enters some sort of drug or alcohol rehabilitation program. NPDB would take the view likely that this should not be reported because there was no adverse action or restriction on clinical privileges. Then looking at investigations, when a hospital or healthcare entity commences an investigation, the fact that an investigation has started or is ongoing is generally not a reportable event. Only if that investigation leads to an adverse action is something really reportable to NPDB. However, if an investigation is ongoing and the practitioner voluntarily or involuntarily surrenders, has a restriction of, or fails to renew privileges, that event is reportable regardless of how long the investigation has been going on. And it's reportable whether or not the practitioner knows the investigation has been opened and is ongoing. So what this means is that a practitioner could voluntarily surrender privileges while, unbeknownst to her, the hospital just opened an investigation related to competence. When those privileges are surrendered, the hospital then has an obligation to report to NPDB because there was an ongoing investigation at the time privileges were surrendered, even though the practitioner didn't know that. And we'll talk about this a little bit, but that's why it's so important for committees and hospitals and healthcare providers to close investigations once they've been opened so that it's not dragging on and just out there in the ether. It's important that we formally close investigations so that we don't run into situations like this. Also, if a practitioner voluntarily limits, surrenders, or fails to renew privileges to avoid an investigation, that is reportable. So Beth Ann, do you want to talk about the Administrative Procedure Act a little bit?
Sure, let's have fun in everybody's day. So before we go through the guidebook's question and answer sections, the new questions that are in the 2018 guidebook, I want to do a quick run through of administrative law because it's important in understanding the legal effect of the guidebook. The Administrative Procedure Act authorizes federal agencies to promulgate rules. So Congress passes the laws and then delegates to the federal agencies to create rules. Some of these rules are substantive or legislative rules, and they're in the CFR on the left, and they have the effect of law. Anything that is interpretive, such as the guidebook, to the extent it differs from the actual data bank regulations, is not legally binding. Regulations are binding when they go through a process that's called notice and comment rulemaking. The proposed rule is published in the Federal Register, and the public is given time to submit comments. The agency then must address the public's comments and concerns in the final rule, and sometimes the comments really change how the final rule turns out. They'll typically have the responses in what's called the preamble to the final rule, and they'll discuss it and how they reacted to each comment and then set forth the final regulation. A final rule has the force and effect of law and is subsequently published in the Code of Federal Regulations, which can be accessed online. Interpretive rules, on the other hand, do not necessarily receive any public input. They're not always published in advance, and they do not have the legal effect that substantive regulations do. They can be in the form of guidance documents, memos, protocols, etc., and therefore they can be changed at will by the agency. It's interesting to note that for the 2015 guidebook, HRSA reached out to the American Health Lawyers Association for comments on the draft, and thoughtful comments were submitted by the AHLA, of which Elizabeth and I are both members, but the AHLA was not offered the chance to comment in 2018, and it's my personal opinion that that is reflected in some of these issues and gray areas that have arisen in these questions and answers. So as we review the questions and answers from the guidebook, please keep in mind that these are the agency's interpretations of the rules and of how the rules apply to different situations. Where they stray from the actual regulations, they are not strictly binding. These are legal gray areas that can have significant implications, so it's important to consult qualified legal counsel when you're not sure about your reporting obligations or how the regulations apply to the situation at hand, because just a detail or two can change how the rules apply. So now we want to walk through the new questions and answers added to the guidebook in 2018 related to clinical privileges and adverse actions. There are other new Q&As that were added, but they're not relevant to you, our audience, so we're not going to go over those. So in question 22, in Chapter E of the guidebook, it asks if an agreement not to exercise privileges during an investigation without actually surrendering the privileges, is that a resignation while under investigation that must be reported? And we just talked about investigations. They have to start, they have to end. The guidebook says yes, as long as other reportability criteria are met. So we have an ongoing investigation and a voluntary, quote-unquote, resignation of privileges. So where things get a little fuzzy is the idea that the guidebook calls this a resignation of privileges and that the resignation is immediately reportable. With a resignation of privileges, which is an action commenced by the practitioner and not the healthcare entity, there is no time frame for how long the resignation must last to be reportable. And the NPDB says that it's as soon as the privileges are resigned, it's immediately reportable. However, with a restriction of privileges that is imposed by the healthcare entity, like a summary suspension or a proctoring requirement, the guidebook requires that the restriction last more than 30 days in order to be reportable. But with this answer, the data bank says the agreement not to exercise is reportable if other reportability criteria are met. So does that mean that the agreement not to exercise privileges has to last more than 30 days to be reportable? It appears that NPDB takes the position that in this situation, because the practitioner is agreeing not to exercise privileges and the healthcare entity is not requiring or imposing the restriction, the length of time the privileges are restricted doesn't matter, and it's treated as a resignation. Now, my personal opinion on this, and not the position of the firm of Brown and Fortunato necessarily, is that resignation is commonly understood to mean a permanent walking away. And if someone is temporarily agreeing not to exercise their privileges, that is a discernible difference that should be honored. But with this interpretation, if you want to stay within the confines of the guidebook, you should have the healthcare entity and the practitioner, they'd both be better off if the entity imposed an investigative or summary suspension or other restriction that triggers the requirement that it lasts more than 30 days, rather than allowing the practitioner to agree not to exercise privileges, which the data bank will treat as a resignation while under investigation, which warrants immediate reporting. This is an effort to restrict gentlemen's agreements, which have become commonplace in the peer review process because people don't want to go through the time and resources and expense to do a full fair hearing. And I think that's where this interpretation is coming from, although personally I do not feel that it is within the square confines of the regulation. Question 23 is another question that was added, and it asks whether a leave of absence while under investigation is considered a resignation of privileges that should be reported. So this is kind of very similar to the last question. And the answer is yes. If the leave of absence restricts privileges, then it's reportable. So in this case, it depends on what happens with the practitioner's privileges while he's on a leave of absence. If the practitioner will be prohibited from exercising privileges while on leave of absence, it will be treated like a resignation while under investigation. Again, it won't matter how long the leave of absence or restriction of privileges is in place. If it's treated as a resignation, it would be immediately reportable. However, if the practitioner could still exercise privileges while on the leave of absence and the investigation does not result in a professional review action that adversely affects his privileges, then it's not considered a resignation and is not reportable. Of course, the answer to this would change if the investigation resulted in some restriction of the practitioner's privileges that lasted more than 30 days, whether or not the practitioner was on a leave of absence. So this is like, we discussed with the voluntary versus involuntary leave of absence for drug. If you know that if they're going away somewhere for 30 to 60 days, they're not, even if you let them have privileges, they're not going to be able to exercise them because they're going to be off somewhere being treated. So I'm not sure why this distinction warrants a question and answer in here, because it could just be a gentleman's agreement like they're trying to eliminate with the other question. So with that, I will turn it over to Elizabeth.
All right, so the next new question that was added is question 24, and it's a pretty lengthy one. It addresses applications for reappointment and resignations that occur prior to a final action on that application for reappointment. So the example given in the question is for a physician who discloses on her reappointment application that she's been named in 3 malpractice cases in the last 2 years. Upon seeing this, the Credentials Committee requests more information on these malpractice cases, and the physician resigns before final action is taken on the application. And the question is, was that a resignation while under investigation that should be reported? And the answer is that it depends. It's going to depend on what the hospital's policies are and why that additional information was requested by the Credentials Committee. If the Credentials Committee always asks for additional information when practitioners are named as defendants in med-mal cases, then it's probably not an investigation. But if it's the number of malpractice cases that cause the committee to question the practitioner's competence, and there isn't a specific hospital policy addressing when additional information on malpractice cases must be provided, then it likely is an investigation and becomes reportable because the practitioner resigned while she was under investigation. The next new question asks about physician resignations while under a quality improvement plan. And the specifics of the quality improvement plan aren't laid out in the question, but the question states that it might include a limit on the number of patients the physician could admit, or a requirement that surgeries be discussed with the department chair in advance, and whether or not that's a resignation. And so, again, the answer is it depends, and there are 2 different issues that we need to look at with this question. If the quality improvement plan was put in place as the result of a professional review, it restricts privileges, and it's in place for more than 30 days, then it becomes reportable. But even if the quality improvement plan did not meet those requirements, it's possible that an investigation was still started here. The healthcare entity needs to look at whether or not this was focused on one practitioner and whether or not it was put in place as the result of competency or conduct concerns. For example, does the quality improvement plan include consequences for the practitioner if the requirements of the plan aren't met? It may be the type of inquiry that typically leads to a professional review action and therefore may be an investigation. But again, while the investigation itself isn't reportable, the entity should be careful to come to a final action on the investigation, either close it out with no findings or take some sort of professional review action so that it doesn't linger if this physician ever resigns privileges or there's another adverse action down the road. And this is like we talked about earlier. If a practitioner does not know that an investigation has commenced and resigns privileges, the fact that the practitioner did not know the investigation was ongoing does not matter, and that is a reportable event. So it's very, very important that we take action on these investigations once we start one. And again, remember, it's not what our bylaws or our definition of investigation is. The NPDB takes a pretty broad view, so just because we don't call it an investigation doesn't mean it isn't one. And the next new question is question 31, which asks if the requirement that a surgeon operate with a qualified first assistant present is a restriction of privileges. And again, we got another lawyer answer, which is, it depends. If this is a new physician and the hospital requires all new physicians to operate with a qualified first assistant when first getting privileges, then it's not practitioner focused and it's not a restriction of privileges. But if there are competence or conduct issues that led to the imposition of this restriction, it's specific to this one practitioner and the requirement lasts more than 30 days, then this should be reported. Question 46 is another new one that deals with a situation where a practitioner's privileges lapse at the end of an appointment period because the MEC recommends the physician not be reappointed to the medical staff, but there isn't time for a fair hearing between the time the recommendation is made and the practitioner's current appointment period lapses. So is that reportable? And the answer here is yes, even though there was no final action by the governing body of the hospital. NPDB treats this as a resignation while under investigation, again, whether or not the practitioner knew the investigation was ongoing. So even though there's no final action here, remember NPDB treats resignations, as we've seen in previous Q&As, differently than other adverse actions, and they will take the position that there's no requirement that the lapse lasts for more than 30 days to be reportable. The last new question and answer regarding clinical privilege actions is about an adverse action taken that's later modified by a court order and how an entity needs to report that modification from the court to NPDB. So here we're assuming the hospital filed an initial report of the adverse action, and how the hospital revises the report is going to depend on the circumstances. So if the court revised the discipline that was imposed on the practitioner, but it's still a reportable revision, the hospital would file a revision to action report. But if the hospital overturned the discipline and basically undid what the hospital had imposed so that it's no longer an adverse action, the hospital should file a void report of its initial report. And with that, I'll turn it back over to Beth Ann to talk about failures to report.
So the failure to report, the consequences depend on who and what you are. They're not too bad if you're a federal or a state agency. The name of the agency will be made publicly available. If you're a health plan or medical malpractice payer, the failure to report adverse actions can be subject to civil monetary penalties, so they hit them in the pocketbook. However, for hospitals and healthcare entities, the consequences can be even more severe. A substantial failure to report adverse actions against a physician or dentist may lead the entity to lose immunity under HCQIA for 3 years. So this is the potential loss of immunity under federal law that protects healthcare entities and participants in the peer review actions from monetary damages. If you think it's difficult to get people to participate in peer review now, tell them that they don't have any immunity for doing so, and you will get absolutely nobody to serve on your peer review panel or credentialing committee. In addition, hospitals and health systems now have an attestation that must be completed every 2 years through NPDB. This is part of the registration renewal process and requires registered organizations to attest that they have submitted all reportable actions to NPDB. Falsely attesting to that can result in legal consequences as well. So the best advice we can give you is to seek the advice of experienced healthcare counsel prior to taking an adverse action or filing a report with NPDB. The path to potentially having to file a report with NPDB is highly nuanced. Reporting requirements and other obligations will depend on the specific details of the investigation, the professional review action, adverse action, the quality improvement plan, the settlement agreement, medical staff bylaws, and a myriad of other factors. The best advice is to involve counsel from the beginning because a lot of issues arise with process and that affects immunity. And so you really want to make sure that you're following the process to support the report before it comes to that. And so the advice of qualified legal counsel is essential. Elizabeth?
All right, so with that, we're done, and we're done a little bit early. We're happy to take questions now or take them offline. We'll put contact information up for both Beth Ann and myself, and please feel free to reach out via phone or email. We will look forward to having you in the other webinars that are being presented as part of this series. And also just a reminder that the previous webinars we've done are up on Brown & Fortunato's website and are available for viewing at your convenience. If you have any other questions, please don't hesitate to reach out to either Beth Ann or myself. Thank you.
Thank you.